Good afternoon and welcome back to the second session of this teleconferencing session. And before the break, we have discussed about what is the hospital, what are the roles of hospitals, and we also discussed about the changing roles of hospitals, and then we discussed about the role of hospital toward the patient, toward the organization, and toward the community. And when Dr. Das was telling you about the role of hospitals towards the organization, he just mentioned there one word that it is the responsibility of the management to maintain the quality of the health services also. And I think all of you will agree that the quality aspect is very important. And another thing is that is with the changing scenario and with the introduction of Consumer Protection Act, that legal aspects and legal ethics and the legal aspects in the medical practice has gained a lot of importance. So in this particular session we'll be talking about the legal aspects and ethical issues in the hospital administration, and subsequently we'll be talking about the other aspects which have been covered in your course 3. So my request again to all of you will be that if there are certain questions pertaining to these areas, you please keep on giving us a telephone call or send your messages through the fax. And now I'll request Professor Agarwal to tell you something about what is this quality, then how we define the quality.
Legal aspects.
Sorry, legal. But the quality will be covering the next. Yes. What are the various implications of the legal aspects, and what is Consumer Protection Act, and what are the implications in the healthcare practices?
Thank you, Professor Arora. I think as mentioned by Professor Arora, this is one area where we medical people are quite weak. Many of us. There are exceptions that some of us are even, they have done their LLB as well, some doctors. But by and large, the situation is that when it comes to the legal aspects, legalities, litigations, we are very poor. And then added on that is the Consumer Protection Act, which is looming large on our heads. And to the extent that now even the government hospitals which are having private wards and who are charging from the patients, those who are admitted in the private wards, they are also brought under the umbrella of the Consumer Protection Act. So these are very, very intricate and complicated issues, and earlier we learn about it, more we learn about the legal aspects and medical legal cases. I think we'll be doing a great service not only to the patients, not only to the hospital, but also save ourselves from the ignominy of the humiliation of visiting the courts and getting penalized by the courts. So when we talk of the the legal responsibilities of a hospital administrator, you see as a hospital administrator we are responsible to the number of individuals, bodies, institutions, and this canvas is very broad actually. We are legally responsible to the owner of the hospital. Owner may be the government, or it may be the trust, or it may be a corporate management. You have been recently seeing the newspaper reports without naming any hospital or the persons. I would like to, very well where I am trying to hint at. The very bad conflict was generated in the hospital. So we have a legal responsibility to the owner of the hospital, whether it is a corporate group or it is government or a trust. And our responsibility, legal responsibility towards the owner is that we are accountable financially. We have to translate the policies and objectives of the management into action. And if we don't do it, we are legally responsible to the management. Then second, group of people or individuals that we are responsible is most important are the patients. We are legally responsible to the patients. Now legal responsibility, obviously one is that no harm should come to the patients from the hospital procedures or the treatment which the doctors are providing. And secondly, that we have to increase the level of satisfaction of the patients, provide good quality of patient care to them. And then we move on to the third set of people and group, and that is the visitors, the relatives, the attendants of the patient. And we have to see that we provide adequate facilities for the attendants. And sometimes we know that the hospitals like Safdarjung, AIMS and other medical colleges have got a dharamshala or a chaultry for the patients who have come for chemotherapy, who have come for procedures where the waiting list is very long and they are waiting for their admission and operations, etc. So that is the third set of individuals. The fourth is the suppliers and contractors. There are so many medicine contracts, supplies, equipment contracts, their annual maintenance contracts. So many contracts are there, and we are legally responsible to that. And we have to see that whatever contracts we prepare, whatever tender we issue in the newspapers, it must have full proof. Technical bids for the equipments, the commercial bids, etc. So, and we also insert the penalty clauses. We try to bind the suppliers to the extent that we drive maximum benefit as a hospital and as a hospital administrator from these contracts. And if there is any violation, there is always the possibility that either of the parties will move the court, and it will be bad that if the opposite party moves the court against you or your hospital. That is one important group. The next important group is staff and employees, isn't it? The employees go against you, in the court for litigation, maybe for career development or for conflict, or maybe the trade union problems, whatever be it. So there are many things, and we have to see that we have the proper policies for the employees' welfare and development so that the litigations minimize, isn't it? And then we have another very important group, and that is the community. Community is in the catchment area of the hospital. We should see that we not only provide good services, but there should not be any harm coming to the community from, say, hospital waste management or radiotherapy sources or materials which may not be thrown into the garbage, like the used sources or the isotopes and various other things used in the diagnosis and treatment of a nuclear medicine department. So that community is a very important group which can go against you in the courts, and it will be very embarrassing for the hospital. Another body that we are legally responsible is the corporation, municipality or municipal corporation or the local body. And our legal responsibility towards this is that we have to legally notify the births, the deaths, other vital events, the notifiable diseases that we have. Now many notifiable diseases have to be informed to the corporation. So these are the legal responsibilities or the broad canvas of then of course police. We are legally, we should have good rapport and relations with the police, local police. So these are, we can always include few more institutions, bodies, individuals, but by and large, as a hospital administrator, we are legally responsible to these set of people. Now we also see that there are two principal divisions of law. All of us know that there is a criminal law and the civil law. We know now criminal law operates on some premise, and that is you have done something against society. So it is society versus individual. And the basic punishment in the criminal law is imprisonment. Now we come to the civil law. Now civil law operates on the disputes individual versus individual basis, isn't it? In hospitals, we are more concerned with the civil law. That's where the CPA is under the civil litigation, civil law. Because criminal law is serious, but criminal law normally operates as per the laid down CPC, Criminal Procedure Code, or the Indian Penal Code, if you've done a murder or a rape or whatever, whatever happens in the hospital, then the police takes care, and then the case is filed, FIR is registered, etc., etc. So we will not be talking much about the criminal law, but we'll talk more about the provisions of the civil law as applicable on us, and that's where we should be careful. Now let's define what is a medico-legal case. Now this is a very good definition. A medico-legal case is defined as one where an attending doctor, after taking history and examination of the patient, thinks that some investigations by the law enforcing agencies are required so as to fix responsibility as per the law of the land. Isn't it? As a doctor, you feel that there is some hanky-panky, and you feel that there is a need for investigation by the police into the case, and then you have to inform the police. That is what is medico-legal case. Then there are some duties and responsibilities of doctor's responsibilities, duties and responsibilities. One is, of course, compulsory notification of the births, deaths and notifiable diseases. Even in the general practice you should do that. Responsibility to call for emergency military services. Reporting of cases of homicidal poisoning. If poisoning cases are there, they become medico-legal. A burn case coming to the hospital becomes medico-legal. Reporting of all unnatural deaths also is the responsibility that we have to discharge. Then there is another very interesting provision in the legal aspect, and that is the professional secrets and privileged communication. There are certain communications which are privileged and secret we are not supposed to share while we come to know during the examination of the patient. So the doctor should not divulge anything which the doctor has come to know in confidence from the patient, and it is moral and legal obligation on our part, and if we do divulge it to people, then goes against the patient, and patient may sue you against the damages. So you are liable for damages. But there are certain exceptions under this privileged communication, that when the doctors render first aid during emergency, you may be required to divulge some secrets or the privileged communication, because that's in the interest of the patient also to save the life. And some pre-employment medical examination for the prospective employer. If the employer has asked for the medical examination, and if there is something which you have come to know, then you have to declare it, because that's your legal obligation. Medical examination for life insurance, and when doctor is appointed by the court to examine a accused. Now we come to the law of contract, because we were talking of the civil law. Civil law has got the law of contract and the law of tort. So we'll be talking mainly on these two aspects. Now what is a contract? As we all know, contract is an agreement between two parties by consent. So contract, as we very clearly understand, it's an agreement. Contract is nothing but an agreement, but this agreement is by a consent. And in medical parlance, the consent is of two types, that is expressed and implied. And expressed is again written and oral. Both are valid in medical legal cases. And the implied consent is implied. That example is that the very fact a patient has called the doctor to his or her house for treatment, or because the patient is suffering, it is implied that the patient has agreed for the physical examination by the doctor. Of course, then there are various limits to that. That is implied. Now consent, has got certain features. Consent should be informed consent. That is the understanding by the patient of the nature of his condition, proposed treatment, and the hazards and risks involved in the treatment. Like, for malignancy, we give the chemotherapy, radiotherapy, there are hazards. And same thing is for certain, conditions where the immunocompromised patients are being treated. So, we have to explain that these are the hazards involved, and the consent has to be timely. It's not that after the operation has been done, then you take the consent. No, it has to be before, and it has to be very explicit. Then it has to be specific for a procedure because the global consent is null and void, that I can do anything and everything with you. No. Any misrepresentation of facts in the consent is not allowed. However, a prisoner can be treated forcibly without consent in the interest of the society or in the interest of the patient's own life. Now, consent, if you take consent and do some illegal act like criminal abortion, that is invalid. The second part, after the law of contract, we come to the law of torts. What is torts? The dictionary meaning of the word tort is breach of duty, that there is a breach in our duty which makes us liable for damages. Okay, you have failed in your duty, and it has got some components, like, for explanation I have tried to divide them into 2-3 sub-components. Law of tort, one is law of intentional interference, which says with malified intentions, if the doctor interferes with the body, property or liberty of an individual, then this will invite the provisions of the law of tort, and you are likely to be sued and then penalized if it is proved. Like, for example, if you exceed the limit of operations, there is some operation but you exceed the limit. Intimate examination of a patient, very well known to all of us. And if you refuse to discharge a patient from your nursing home or the hospital, or you divulge a privileged communication. Then second thing in this we can discuss is the professional negligence. That means doing something doing something that one is not supposed to do, or failing to do, sorry, it's spelling mistake, or failing to do something that one is supposed to do. That means professional negligence would mean that you are supposed to amputate the right lower extremity because of the gangrene, and you have amputated the left healthy limb because of some confusion, and that becomes a very, very serious criminal negligence, and that will invite the provisions. You have operated on the abdomen and left behind a swab or a forceps or some instrument leading to the peritonitis or the death of the patient. We know the professional negligences of the various types. I have talked about the very serious type of the professional negligences. But the burden of proving the negligence, fortunately for the doctors, the burden of proving the negligence lies on the plaintiff, that is the patient. And the patient has to establish that the doctor was duty bound to give this service, and there was a failure in your duty which has led to the damages. The damages are quantified in physical terms. Physical means monetary terms, money terms. And the criminal negligence, as I mentioned, is amputating on the healthy limb, and that's also called as res ispa loquitur. Res ispa loquitur, you get a short note sometime. It means that a gross criminal negligence has been done by doing abdominal surgery and leaving behind something, or amputating the healthy limb in place of the gangrenous limb. That comes under the res ispa loquitur. But if we are careful, a doctor will not be, court are very generous by and large. A doctor is not held guilty of negligence if the doctor exercises reasonable care of his skill, because court appreciate, and we can also have the second opinion, court can have the second opinion. There are always some risks which are inherent in any form of treatment, and the doctor will not be negligent if they cause damage, provided that he or she has taken proper precautions. Even in two similar type of operations performed on two similar kind of adults, one may be treated and recover completely, the other person may suffer with some kind of problems. So the human body may react to certain kind of things despite your best precautions. Under those situations, the court will give the allowance to you, because you have taken all precautions, and if you have erred somewhere, then they are very liberal and generous, because there are some inherent risks in the medical sciences. It's not as exacting as the robot performs the mechanical Maruti car fixing spare parts and various assembling of the car. It's not like that. Human body may react differently to different to same stimuli, or to same kind of things. The third is very interesting, this one. Under the law of tort, we also have the vicarious responsibility, where you might have directly not done anything, but even then you become legally liable for punishment, compensation. And the law holds that an employer, that means the medical superintendent or the hospital administrator, is responsible not only for his own omissions or commissions, but also of his employees. Or head of the department of medicine will become liable for the negligent act of the junior doctors in training, like interns and house surgeons. So you should not give independent surgeries or independent management of serious ICU or ICCU cases to them. But yes, if there is some negligent act by the senior doctors, regular medical officers or a specialist or teaching staff, then they will be liable themselves for the compensation or the medical legal cases. But normally the vicarious point is that the junior doctors in training, if they do some mistake which is probably minor in nature, then the intern or the house surgeon will get away with that mistake, but you as a hospital administrator will be legally responsible. That is vicarious responsibility. I hope I am clear. Therefore, hospital management and you as an administrator cannot be held responsible for negligent act of the members of the superior medical staff, but will be held responsible for the mistakes of the resident doctors, like interns and house surgeons, not the senior residents, because they are senior people, they are postgraduates. Nevertheless, every doctor will be liable in law for his own gross negligence or gross criminal act. So, as a chief of the hospital, what we are supposed to do to minimize the litigation is to identify the potential problem areas, lay down the procedures like hospital manual, supervise and leave behind the evidence that you as administrator have taken due care and precautions. And therefore, these are the sensitive areas in the hospital where you should be very, very particular. In these areas, you should take no liberties. You should have serious, you should have doctors and nurses and staff who should be very, meticulous in documentation, in treatment, prompt service, and then certainly mortuary, and these are the areas where wrong labeling of the body and handing over the wrong body to the wrong religion. There have been instances that the body belonging to a particular sect or religion has been handed over by mistake to some other religion, and the last rites were, instead of the cremation, it was buried. So various things can happen. You have to be careful. So these are the areas where we have to be very, very, especially, including the equipments and building, fire hazards and safety, and then of course the documentation will save you in many such cases if you have the thorough documentation. Now let's discuss something briefly about the Consumer Protection Act. You see, there was
call from Delhi too.
Yes, Delhi too.
I'm Dr. Mandeep speaking from Delhi to Rajghat.
Yes, Dr. Mandeep, what is your question?
My question is regarding vicarious responsibility.
Yeah.
A physician or a house surgeon or intern, a general surgeon commits a mistake. So the head of the department is responsible or the MS is responsible?
In this case, head of the department.
If the MS is responsible, and if the compensation is awarded to the victim, it's the hospital which will be paying, or the MS will be paying from his own pocket?
Yeah, very interesting. You see, if it is a government hospital where every patient is free, then CPA provision will not be applicable on that hospital. But yes, if this is a private hospital or the mixed kind of a situation where we have the government hospital plus the private ward, yes, CPA is applicable. In any case, if the house surgeon or the intern does something wrong, First of all, the head of the department of surgery should not have given a free hand to the intern and house surgeon to operate. They should always help and assist the senior surgeons in operations, not to carry out the operations independently. But there may be some people who, somehow manipulate and somehow go into the surgery, try to impress upon the local nurses and OT staff and operate on a patient without the knowledge of the head of the department or something. Even in such situation, the head of the department of surgery will be responsible. Vicarious responsibility will be on the head of the department, and then ultimately it will be the overall hospital management which will be taken to legal compensation, and whether head of the department or the hospital pays, but the intern and house surgeon can escape the penalty of damages and compensation in these cases. It will be either the head of the department or the hospital management, but I feel it should be the head of the department because he has allowed that, and that is what I think. What do you think? Probably I feel like that.
There are few issues involved with this. One, as Professor Agrawal has said very much, it is one of the judgment actually which is I read in the newspaper. It very clearly says it is the responsibility will be divided with the both head of the department and the superintendent. That is what it is says. Secondly, that is how much who will pay, the court would decide. It is not the 100% compensation will be paid by the doctor. The part of it will also be paid by the HOD or the management or the hospital trust or the government, whatever the ownership is, because it is the combined responsibility which is everyone. That is how you find that in abroad there is very heavy coverage of insurance. Probably they are not too far where people also have to cover themselves up, or the organization has to take insurance of these people and they will have to pay the premium for this particular person. So it will depend on case by case basis, and the court will decide what percentage compensation has to be paid by superintendent, oblique HOD, oblique whatever. Yeah, that is what I thought.
Thank you.
Yes. To proceed with the Consumer Protection Act, if we look here, this CPA came into force in July 1987, and it was not applicable to the hospitals to begin with. And the purpose of this CPA was to provide better protection to the consumers, because the civil law took lot of torturous route and delay and inefficiency. So it is compensation oriented, and basically to remove the defects of the civil litigations of delay, expensive litigations and complicated procedures. And now machinery is that we have the Consumer Protection Council and the consumer courts. Consumer Protection Council is there at the state level as well as at the at this national level and the state level, and its job is to policy, advisory in nature. But the consumer courts, these forums are there at the district level, at the state level and at the national level. And at the district level, the compensation has been increased. Earlier it was up to 5 lakhs, now it is up to 20 lakhs of rupees compensation normally is dealt with at the district level consumer forums or consumer courts. And from 20 lakhs to 50 lakhs, the compensation is dealt with at the state level consumer protection courts or forums, and then more than 50 lakhs it comes to the national level consumer courts. Now as against the compensation of lakhs, 50 lakhs or whatever, if there many a times the complaints are frivolous, because sometimes you must have heard a name, ambulance chasers. Who are these ambulance chasers? These are sometimes lawyers who try to misguide you, and they try to, there has been some minor problem or some minor negligence in treatment which may not invite the award of compensation, and then somebody, or sometimes it is your professional rivals. One surgeon will operate, the other will incite that, oh, this is something wrong which has been done, and you can go into the consumer court and file a complaint and get compensation, and it turns out to be a frivolous false complaint. For that the maximum fine is only rupees 10,000. So it is, I think, very imbalanced. And there was a historic, now when the hospital and the doctor came under the purview of the CPA, it was only as late as 1992, because the act came in 1986, but the patient was declared a consumer only by the Supreme Court historic judgment by Justice Iradi in April 1992, that the patient is also a consumer, and this was upheld by the National Commission on Consumer Dispute. So to overcome these problems of the CPA, we have to do certain things. One thing that I mentioned in the beginning, is we should know how to communicate with the patient. We have to be polite, compassionate, give a listening ear, explain the details of the disease, the complication and sequelae to the patient, keep them informed, have a dialogue with them. Ethical medical practice is very, very important, because many of us are in private practice indulge particularly in unethical practices. Do not over-investigate or overcharge the patient. Do not glamorize your practice like, okay, your clinic has got a lithotripsy. You have a small hospital and you have got a lithotripsy machine, and then you glamorize that, oh yes, I can remove the renal stones without any problem within no time and all that. That is glamorization. And if you do that and the patient gets some problem, then the patient may go to the MRTP monopolies. Restrictive Trade Practices Commission is there, and they can award compensation against you. And then always try to have second opinion consultation with the experts in the complicated cases. And then lastly, we should try to keep abreast with the latest developments by reading journals, by having participating in conferences, journal clubs. Then have a professional amity. As I mentioned, that most of the times the cases are because of professional rivalry, and number of cases can reduce if we try to maintain professional amity within the our group of doctors, by having conferences, meetings, and forums like medical associations, IMA or City Medical Association, and try to sort out these kind of problems, that we should not have this professional rivalry. So because the majority of the consumer protection cases are filed due to professional rivalry. Then Dr. Singh has mentioned very nicely that we should try now to have, hospitals should try to have a policy that there is a heavy medical insurance, indemnity insurance, these things, so as to protect us from the compensation part. And meticulous documentation will save you most of the times. And I mentioned briefly about the ambulance chasers. We have to be careful. And with these things we can minimize the litigations if we try to follow these things. I think that was the main thing that I thought I'd like to share in the legal aspects and the Consumer Protection Act.
You have covered very exhaustively in detail. I think the students must have learned that what are the various legal implications, legal aspects of the medical care. Sir,
I'd like to add 2 points here for the information of the students. There's a lot of discussion now on RTI, right to information, which is not there in your modules. It is not given. In fact, there was a 1 full day seminar in All India Institute of Medical Science. Now legal luminaries and hospital and health authorities are thinking.
Yes, Delhi 2, please.
Hello.
Yes, please.
Hello. Hello.
Yeah. Hello, yes, please.
This is Dr. Chabri speaking, sir.
Doctor?
I wanted to ask you one thing. You have enumerated that these are the things which contribute to negligence. But how can a layman, a relative of a patient who is sitting outside the ICU, who does not even know what is happening with this patient, and he has no, when the patient is discharged or the patient dies, they don't have any records of what has been done with the patient, how can he go out and use this Consumer Protection Act? And number 2 is, we are talking on compensation, but I think a loss of life, you cannot compensate it in any manner, whatever the amount of compensation is given.
Thank you, Dr. Saeed.
I would like you to please comment on these.
Yeah, now your first question. As you are aware that the hospital has to give the information to the patient. Patient can get his case sheet, or his next of kin can get the case sheet. Earlier, it was the decision first time was given by Maharashtra High Court. Earlier, people thought the case sheets are only to be in the custody of the hospital. It is no more so. Patient, his next of kin, or even some attorney, if he has been authorized by the patient or the next of kin after the death, can always get the case sheet. And you might have seen in the newspaper, the people are getting aware. Not only there's even a beating around going on between the doctors and the people because they have bad communication and so many other things. So to say that everybody will not have information what is in ICU may not be right to that extent. Secondly, there are some ethical responsibility of the hospital management. And you would find that certain things which, if it has happened, it is the duty of the medical management that they must investigate and take preventive action or otherwise. Because if they hide and something comes up at a later date, they will be equally responsible. So these are the one. Second is the compensation. That is an emotive issue, but everything in terms of finances are being compensated, may it be accident victim, may it be death or otherwise. I mean, this is a routine thing. We do understand that it cannot be done. So I was just coming, I just give you 1 minute. The RTI is the one thing which have to be now is being considered, that as a manager, what information about the patient I can part with it. How much about the hospital I can part with it. These issues are still being debated. No concrete document has been prepared, and every stage it is being debated, and probably soon something will come. And the last thing you might be knowing, there was a decision in the court, and the ESI hospitals have also now come under the Consumer Protection Act. This was in Times of India almost only 10 days back. Thank you.
Thank you, Dr. Singh. I think students must have got a insight into the various legal issues, and I think Dr. Sandeep, who raised the question from Delhi, to have given certain insight into the other students also. So with this, we'll close down here, and we'll be back at 4:30 for the rest of the portions of the course 3 to be covered.